Okay. Another area that you need to know about, that you'll need to know about both for civil and criminal, and the differences between the responsibilities of personnel in the criminal and civil justice system. So we'll look at civil later, but now looking at criminal. Obviously, what personnel do we have? It's the judge, jury, the legal practitioners, and the parties. Okay, so for the judge, what are their responsibilities and roles? There's been, you can have 10 markers on this as well, guys, by the way. So this is one that really commonly comes up, and I recommend knowing in a lot of detail. So the judge manages the trial, ensuring that correct court procedures are followed, giving directions, giving instructions on what the accused and prosecution have to do, such as giving deadlines, clearing up anything that's unclear made in submissions or evidence by the parties. They decide whether evidence is admissible and whether it can be used in court by making sure it complies with the strict rules of evidence that are stated by the Evidence Act and common law, judge made law. They attend to jury matters and instruct the jury and tell them what to do and what their role is. And in the criminal justice system, they ultimately hand down a sentence for every single case. So they tell the accused, the prison term that they will have to serve. If a jury is not appointed, remember juries are only used for indictable serious offenses. So if it's a summary offense, the judge also has a role to hand down the verdict, whether the accused is guilty or not guilty. However, in indictable offenses, this is the role of the jury. So when you discuss that in questions, make sure to specify. The jury's responsibility is to be objective. They need to let go of any personal bias and decide the case based on the law and facts alone. They must listen to and remember the evidence and take note of it and really follow along the trial and pay attention and deliver a verdict, but they do not hand down a sentence. So, with a jury of 12 people, a unanimous verdict is usually required, meaning 12 out of 12 jurors during their deliberations must decide whether the accused is guilty or not, and they must all agree. But a majority verdict, which is 11 out of 12, can be accepted for certain offenses as well. Now, our legal practitioners are lawyers, okay? So the prosecutions and the accused person's lawyers. Some of their responsibilities, there'll be a lot more in your textbook, are to comply with their duties to the court, such as to act ethically, no deception, no misrepresentation of the law or their client's case, give their best shot at legal representation as part of their work. So they must present their client's case in the best light possible, no matter, again, they have to kind of let go of any bias. They have to let go of thinking, I do think that the accused I'm representing did it, but they still have to do their best, okay? They inform the accused of their legal rights as well and help them to understand court processes and information. They may give advice to the accused person on what the best course of action is, but they cannot force the accused to comply with that. They can just give that information and advice. Now, the parties are the prosecution and the accused. They give an opening address to the jury and judge, present their case to in an open and diligent manner, and they make submissions about sentencing. We could also add a closing address. So there's an opening and a closing address that each party has to do. This is where they basically summarize the case and make an appeal for their side. Obviously, if there is lawyers, the legal practitioners do this on the party's behalf, but this is the party's role, okay? So in the opening and closing address, they may be summarizing as the accused why the accused hasn't done anything wrong and why the accused should be found not guilty, and the prosecution will be doing the opposite and saying this is why the accused is guilty, this heinous crime, etc., etc. And when they make submissions about sentencing, that's usually done towards the end. This is just with regards to The accused will talk about why they shouldn't be found guilty, why they don't deserve a harsh sanction, it should be a lenient sanction, and the prosecution will be doing the opposite.